For our next story, we have revised guidelines that were just issued by the United States Patent and Trademark Office. So as you all know, or many of you know, my day job is as a patent lawyer. So this is my bread and butter that I deal with on a day-to-day basis. And I thought we might cover this because this is, I believe the fourth major guidance that the U.S. Patent and Trademark Office has issued relevance to the Alice v. CLS Bank decision from a couple years ago. So there was a major patent case called Alice v. CLS Bank, which tried to delineate when an invention becomes an invention. And the U.S. Patent Office has issued periodic guidance in light of both Alice and, of course, the other cases that have since followed that. So there have been lots of decisions that have since followed, and the United States Patent Office keeps updating its guidelines every once in a while to take account of all the new guidelines that have been issued. So they just issued this guidelines to be the new interpretation guidelines for examiners. So we're going to take a look at this and see how the Patent Office tries to distinguish when an invention becomes an invention versus a mere abstract idea. So let's get started with that. So the first thing that the patent law says is that you cannot patent pure math. You can't patent a mathematical concept. You can't patent a mathematical equation. And so, a pure math discovery is just an idea. It's an abstract idea. It's not an invention. So the first thing the Patent Office is trying to clarify is what a mathematical concept is. So we're going to read this. When determining whether a claim recites a mathematical concept, that is, for example, mathematical relationships, mathematical formulations or equations or calculations, examiners, that is patent examiners, should consider whether the claim recites a mathematical concept or merely includes limitations that are based on the concept. A claim does not recite a concept if it only is based on or involves a concept. For example, a limitation that is not merely based on or involves a concept described in the specification may not be sufficient to fall into this grouping, provided the concept is not recited in the claim. So basically what they're saying there, among other things, is that a patent is defined by its claim language. It's defined as what you're claiming. And so to say that a mathematical concept is in the specification, that is background material or other description, is not sufficient in and of itself. You have to look to what is actually being claimed first and foremost. Not what the invention, broadly can be understood, but what's actually in the claim language. Examples of a mathematical relationship recited in a claim include a relationship regarding a relationship between rate and temperature, which can be expressed in the form of an equation. For example, Diamond v. Deere, which did with the curing of rubber, or a conversion of binary, decimal, and pure binary numbers, or a mathematical relationship between enhanced directional ratio activity antenna conductor arrangements. So that would be the example of mathematical relationships that have been previously found in claim language. A claim that recites a numerical formula or equation will be considered as falling within the concept grouping. In addition, there are instances where the formula or equation is written in a text format should also be considered as falling in this grouping. For example, the phrase determining a ratio is merely a textual replacement for an equation. Fair enough. A claim that recites a mathematical equation will be considered as falling within the concept grouping. A calculation is a mathematical operation such as multiplication or calculation using mathematical methods. For example, performing a resampled statistical analysis to gain a resampled distribution, so redoing statistics, calculating a number representing an alarm limit using a mathematical formula, or using a formula to convert geospatial coordinates into natural numbers. Under the guidelines, fundamental economic principles or practices describe certain matters relating to economy and commerce are to be considered certain methods of organizing human activity. The term fundamental is not used in the sense of old or well-known, although that may be fundamental. The practice provides examples of fundamental economic principles. For example, local processing of payments for remotely purchased goods, using a marking affixed to the outside of an object to communicate information about the object, or placing an order based on market information. According to the guidelines, commercial interactions or legal interactions include subject matter relating to agreements in the form of contracts or legal obligations. For example, a transaction performance guarantee, which a contractual relationship involves. A processing insurance claim for covering loss. So you can see here the office is talking about kind of standard methods of organizing relationships, standards methods of engaging in human. Tax-free exchanges of real estate, where the legal exchange is a legal obligation, or arbitration. Using advertising as an exchange or currency, offer-based price optimization to know the perfect price to offer, structuring for sales or marketing, processing credit applications between a consumer and a dealer, processing information through a clearinghouse where the business relationship is fundamental to the relationship. According to the guidelines, managing personal behavioral relationships include social activities, teachings, and following rules or instructions. For example, a set of rules for playing a dice game, voting, verifying a vote, and submitting a vote for tabulation, assigning hair designing to the balance for the head shape, and a series of instructions on how to hedge risk. Claims do not recite a mental process when they do not contain limitations that practically can be performed in the human mind. For example, a claim to a method for calculating an absolute position of a GPS receiver and an absolute time of receptance of coordinates, a claim to detecting suspicious activity by using network monitors, a claim to specific data encryption method for computer computation, or a claim to a method for rendering a half-tone image of digital image. So these would be examples of things that cannot be performed in the human mind. The human being cannot, a normal, ordinary person, a skill in the art, a normal, ordinary person cannot do this in their mind. There probably is someone somewhere who can do it in their mind, but that's not the standard. The standard is an ordinary person, the ordinary man test, basically, the ordinary person in the art, an ordinary person who's familiar with the technology. So, you're a run-of-the-mill person who's a technologist. Can they do this in their mind? And the answer to that question is no, they can't. They can't make these kind of computations in their mind. So that's example of things that do not qualify as mental methods. Examples that do include mental methods include a claim of collecting information, analyzing, and displaying certain results, where that's done at a high level. Because it's high level, it can be done in the mind. Claims to comparing a certain sequence of genes and determining the existence of alterations, where the claims cover any way of comparing sequences, so they can be performed in the mind. Again, give me a sequence and I can determine if it's deviating from another sequence. I can do that in my mind if it's general enough. A claim to collecting and comparing information, which can be performed in the mind. Determining a head shape and applying hair designs, which can be performed in the mind, in fact, is performed in the mind every single day by talented hairdressers everywhere. Half-toning can be done in the mind? I don't know, man. That's asking a lot. I mean, you have to distinguish between the concept being done mentally and actually executing it mentally. For example, can Bitcoin be done in the mind? Well, I can explain it to you using words, but you can't actually perform the process in the mind. You can't do it mentally. You need computers and networks and signatures and all kinds of stuff to do Bitcoin. Can you do a halftone in the mind? Well, I can describe to you what it is mentally. I can describe to you the concept, but can you actually do it in your mind? Can you in your mind compute what a halftone would be? Can you actually do that? I don't think you can. I mean, I don't think I can. You can mentally understand what it is, but to actually do it mentally, I don't think you can execute that in your mind. Whereas if you give me two lists of things, I can compare if they're different. I can do that in my mind. It's capable of my human ability. So, and as to your question, what to a math savant, that again goes to the standard. The standard is the ordinary person. Ordinary person of skill in the art. An ordinary person of skill in the art. An ordinary technologist. So the question is an ordinary person in this field. So if you're doing half-toning, get me 100 experts in the field of digital imaging. Give me 100 people. Pull it essentially at random. How many people can do that in their mind? 1? 2? I mean, maybe, but can an ordinary person do it in their mind? I don't think so. I mean, every single one of those people can understand it in their mind. Every single one of those people can tell you what it is, but they can't actually do the computation. They can't actually compute it out. They can't actually describe to you what the result would be. They can tell you conceptually what it means, but they can't perform it. It's not possible. So this is not a savant test. It's an ordinary person test. Claims can recite a mental process even if their claim is being performed on a computer. In evaluating whether a claim requires a generic computer that recites a mental process, examiners should be careful to consider the broadest reasonable interpretation of the claim in light of the specification. Examiners may review a specification to determine if the underlying claimed invention is described as a concept that's performed on a generic computer in a computing environment or merely as a computer that's used as a tool. In these situations, it's considered to be a mental process. So if it's just a general computer that can perform it, it's not enough. Merely taking an idea and saying to a computer apply it is not enough. That's Alice directly. You can't just say, do it on a generic computer requires something more. If a claim recites a limitation that can practically be performed, that's the key question. Practically be performed in the human mind, the limitation falls within the mental process grouping and that claim restricts enough the idea. Can it be done practically? Can a person of ordinary skill actually do this? If yes, then it's abstract. If not, then it's not. The use of a physical aid to perform the mental step does not negate the mental nature. So you can use pen and paper. Just can you do it? According to the guidelines, the question of whether a claim is directed to a judicial exception is now used in a two-pronged inquiry. Prong one, which is discussed in this update, asks if the idea recites an abstract idea, law, or natural phenomena. Under that prong, the mere inclusion of a judicial exception, such as a formula, in the claim means the claim recites an exception. So step one, does it recite an exception? In the claim language, does the claim recite cite something? Is it an abstraction in the claim? Is it a mental process? Is it a human process? Is it a mere idea? Is it a mere mathematical formula? You look into the claim language to see, does it actually step? That's step one. Is it an abstract idea that's claimed? However, mere recitation of the exception does not mean it's directed to. Instead, under prong two, a claim that recites a judicial exception is not directed to if the claim as a whole integrates the recited exception into a practical application. So again, you're looking to the claim as a whole, not merely one limitation, but you're looking to a whole. So again, the go-to point is Diamond v. Deere, the curing of rubber. Diamond v. Deere has an equation right smack dab in the middle of the claim, but it's used for a practical result. It's used to cure rubber according to a formula. And that's not something that can be done in the mind, either practically or, philosophically. You can't cure rubber. You have to actually have a machine to do it. So it's smack dab in the claim, but it's integrated into a practical application. Therefore, it's not a mere idea. That's what they're talking about. A new mini flowchart was depicted to depict the two-prong analysis that's now performed in order to answer the Step 2A inquiry. This flowchart is also reproduced. The figure demonstrates how to provide the guideline. So here's how you do this. So let's actually go through both flowcharts so we can understand together. All right. So you want to know if a claim is abstract or not. Here's how you do it. Here's the steps that you go through. Step one, establish the broadest reasonable interpretation of the claim as a whole. So a claim is the actual I claim. It's at the back of the claims. It says I claim, and they're preceded by a number, 1, 2, 3, 4, 5, 6, 7, whatever. So we look to the claim. We look to the claim as a whole. We don't look to an individual limitation. We look to the entire claim. And we're interpreting it as a whole. The whole claim, but what's the broadest reasonable interpretation of the claim? So that's what we have to do. And in light of the specification, not in the abstract, but in light of this particular specification, what is the broadest understanding that can be understood of the claim? So that's step one. We look to the claim, and then we look to the broadest reasonable understanding. A person of ordinary skill in the field, how would they understand the claim in light of the specification? Then step one, is the claim directed to a process, machine, manufacturer, composition of matter? If not, we're done. Because it has to be one of those statutory categories. It has to be a process, a machine, a manufacturer, composition of matter. That's 35 USC 101 on its plain text. It must be directed to one of those things. If the answer is no, we're done. End of analysis. If the answer is yes, it is directed to one of those things. When viewed as a whole, is it self-evidently eligible? If so, it's eligible. Now that doesn't speak to prior art, make a note. That doesn't mean the claim is allowed. It means it's eligible to be allowed. This is only an eligibility determination. So once we're done with this, we still have to go to prior art. So just because we said it's eligible doesn't mean that it's going to be allowed. We have to go to what the prior art does or does not teach. But is it on its face clear? If the answer is yes, we're done. If the answer is no, then we go to the next step. Is the claim directed to a law of nature or natural phenomena? If no, then we're done. It's not directed to that. If the answer is yes, then we get to, does it recite significantly more than the exception? And that's really the complicated part, 2B. It's a significantly more step. But that's the step where we say, is it significantly more than the abstract idea? Or is it merely taking the abstract idea and saying, apply it on a computer? Or is it doing it in some way to manifest some sort of particularized result? So that is the kind of operation we're trying to apply. So now we have a revised step 2A. So now we have this new chart. So prong one, does the claim recite an abstract idea? We just discussed that. If no, it's not directed. If yes, does it recite additional elements that integrate it? If no, we go to the next analysis. But if yes, we're done. So if it's an integrated idea, then it's integrated. It's not an abstract idea. It's an abstract idea that's integrated into a practical application. The curing of rubber, the computation of the halftones. It's mathematical, it's useful for some sort of purpose that we can, it's achieving some sort of concrete, understandable result. So that makes sense. And if not, then we have to do further analysis. So that makes sense. Explained in the guidelines, the evaluation of prong 2 requires the use of considerations. For example, improved technology, efficiency of treatment, or improvement with a particular machine identified by the Supreme Court to ensure the claim as a whole integrates the exception into a practical application that will apply, rely, or use the exception in a manner that imposes a meaningful limit on the exception. Such the claim is more than a drafting effort designed to monopolize. So we're not looking to like clever crafting tools. We're looking to, are you using for some sort of practical, meaningful purpose? Is this actually a meaningful thing? And this is what examiners have to determine when they're looking at this claim language. For example, if additional limitations reflect an improvement in the functioning computer or an improvement in the field, the claim integrates the exception. No further analysis is required, and the claim is eligible as to step 2A. Again, this is eligibility, not allowability. You still have to do the prior art analysis. This is just allowability. For example, in a prior case, the court concluded the claim recited using a plurality of network monitors to analyze specific network data and integrate generated reports from the monitors to identify hackers and intruders. Okay, that makes sense. So you're looking at these reports, you're doing some sort of analysis on it, and you're going to say these are hackers or intruders or not. Is that something you can do in your mind? Not particularly. It's something that conceptually makes sense, but is it something that you can actually execute in your mind? I mean, not given the kind of data that is going to and from computers, right? It's too much stuff for one person to do in their mind. So you could understand a use case in your mind, but could you actually execute this mentally? No, you need a computer to look at this stuff. And so it's saying, look, you're looking at it for a practical impact. You're analyzing traffic, you're integrating it into reports to make a determination as to whether they're hackers or intruders. Again, this is eligibility, not allowability. So whether or not there's prior art is not the issue. The issue is it eligible? And the court says yes, and I would tend to agree. If you have pen and paper, yes, you could. Well, you could in a single instance, yes, but you couldn't really, given like think about it. If you're a computer of any sort of size, it's like the amount of traffic you have coming in and out is too much. It's too much to do. Yes, you could do a single use case. Can you do like every use case? Can you do the amount of traffic coming through? It's too much for a human being to do. It's too much for 1,000 human beings to do. You need a computer to do these analysis because of the amount of traffic. So yeah, exactly, evil coleslaw. That's the question. Is it practical to do it? Can you conceptually do one case? Sure. Could you practically do one case? Sure. Can you do the amount of traffic that's coming through your server? Not a chance in hell. No way. No one can do this. It's not practical for you to do it. Can't be done. The two-prong analysis considers the claim as a whole. The limitations containing judicial exceptions as well as additional elements beside the judicial exception need to be evaluated together to determine whether the claim integrates. Again, this is a holistic together test. It is not proper to separate one thing from the rest of things, which I see being done by a lot of amateur patent people out there. They take one thing from a claim language and they break it apart from everything else. You can't do that. You have to look to the claim as a holistic whole. What is the claim as a whole being directed to? The claim controls what you're talking about. So it's not enough to say there's one thing there. For example, in a prior case, the court determined the claim recited an abstract idea of filtering. However, it claimed the invention improved technology because the tool was imposed at a specific location, remote from end users with customizable features. Yes, filtering in the abstract is abstract. Filtering is something that can be mentally considered. But when you put it in a specific location, when you consider it with specific kind of filters for specific purposes, now you're reducing it to a practical application. It's more than the idea of filtering. It's filtering with additional stuff, and the additional stuff matters. You could hire more people to make it practical. I don't know, man. Can you really envision a situation where you're going to have a bunch of people in whatever situation you can dream up trying to evaluate whether network traffic is a hacker or not? By the time they're done doing their evaluations, it's long too late. If you have your boiler room of choice somewhere where a bunch of people are evaluating whether it's hackers or not, by the time someone realizes it's a hacker or not, it's already all over. So it's like you can't do it fast enough. An important consideration to evaluate when determining a claim as a whole abrogates an exception into a practical application is where the claim invention improves the function of the computer. The courts have not provided an explicit test. However, the rules provide for a detailed explanation. In short, the specification should be evaluated to determine if disclosure provides sufficient details such that one of ordinary skill in the art would recognize the claim invention as providing improvement. Would a person of ordinary skill say this recognizes an improvement? Is the technology being improved? That's the question we're trying to ultimately get to. Is the technology being improved? That's the question. The specification need not set forth the improvement, but it must describe it so it would be apparent to someone that it does set an improvement. If the specification sets forth the improvement, the claim must be evaluated to ensure the claim reflects the improvement. Again, this is all going down to the claim language. Even if it's in the description, is it in the claim? That's the important thing. Consideration of improvements is relevant to integration analysis regardless of technology. Consideration applies equally to whether it's a computer-implemented invention, an invention in lifestyles, or any other technology. For example, in a prior case, the court noted that claim process for preserving hepatocytes could be eligible as an improvement technology because the claim achieved a new and improved way for preserving the cells for later use, even though the claim is based on discovery of something natural. So again, yes, we discovered something that's natural, but we improved nature. We made a better way of doing it than is available in nature. We couldn't claim the way nature does it, but we can claim an improvement. That's totally fine. That's like what you do every single day. You look at what nature does and you make it better, or you figure out a way to apply it in a way nature didn't intend. So that's perfectly fine. During examination, the examiner should analyze the improvements consideration by evaluating the specifications and the claim to ensure that the technical explanation of the asserted improvement is present in the specification and the claim reflects the improvement. Again, it needs to be described in the specification and the claims need to actually claim it. They're not expected to make a qualitative judgment on the merits. That's true. It's not qualitative. It's not how good is it. It doesn't have to be good. It just has to work and it has to be functional. You can get a patent for something that's not particularly good. If it's a new way of doing it, as long as it achieves a technological result, and as long as it does it new, you'll get a patent for it, no matter how good or not it is. It doesn't have to be better than the technology of field, because you never know what's going to happen in the future. Someone comes up with a stupid way of doing something. You never know how that's going to influence that field or another field in 50 years. Maybe it's not good in this field, but it's good in another field. So someone comes up with a stupid way of doing something. You're like, that's stupid. But it improves knowledge, and that knowledge may be useful here in the field or in another field. So it's still patentable because it's improving the nature of knowledge. The fact that anyone wouldn't use it is not relevant because knowledge is being manifestly improved, and that's what we're trying to do. We're trying to increase technology, and that doesn't go to a qualitative judgment. It goes to whether or not the technology is being furthered or not. As discussed above, the guidelines identify several other considerations. The considerations that may indicate integration include implementing the judicial exception with a particular machine or manufacturer, the word particular being somewhat important in that sense. It has to be a particular machine or manufacturer, not just a general machine, but a particular machine, affecting a particular transformation. Again, it's not general, it's particular, it's manifest. Particular transformation or reduction of article, and applying it in some other meaningful way. These are words that actually make a difference in the sentence. Considerations that may not indicate integration include merely reciting the words apply or the equivalent, adding extra solution activity, and generally linking the use to exception to a particular environment. Yeah, just because you do it in an environment is not going to work. It has to make a difference. It has to matter that it's being done in that environment. So that is what matters. If it's stupid and it works, it's not stupid. Pretty much true. Yeah. If it's stupid and it works, it's not stupid. It may not be better than the art, but it could be better someday. Who knows? Who knows what the future will bring, right? In fact, if you can prove your idea is pretty stupid, it's a very good way to get a patent because it makes it non-obvious. No one would think to do this. It's stupid. That makes it non-obvious. That's a pretty good way to get a patent, actually, if you can prove it's stupid. The examiner says, this is stupid. No one would do this. And the applicant says exactly. And then you're like, oh, okay, well, patent granted. So that is a brief summary of the subject matter guidelines as it applies to ideas and actual inventions. So long story short, mere ideas are not patentable. Mere abstractions are not patentable. Mere math is not patentable. Mere laws of nature are not patentable. If you find it in nature, if you discover it in the Amazon, if you discover a law of math, if you discover a law of physics, if you discover an idea, we're really happy for you. But whatever else you get, you can't get a patent for it because nature invented it first, or math invented it first, or what science invented it first. You can't get pure science, but you can absolutely get an application of that. And so you're looking for a meaningful application. You're looking for a practical application. You're looking for something where it matters that a particular technology is doing it. You're looking for improvement of technology. So hopefully this is somewhat helpful in highlighting the idea, invention, separation that Alice and his progeny are going for. And it's really important that you not look at limitations in isolation. You don't look and just say, well, there's a math equation here, or this is this thing here that's abstract. You have to look to the entire claim language and analyze it as a whole. In light of specification, according to a person of ordinary skill, a person who's knowledgeable in the field, and does it make the technology better or different in some way? If the answer is yes, then you move on to prior art analysis. But if it changes the art, then it's eligible. Whether or not it's allowable is a whole other set of questions that deals with prior art and what's known. But as long as you're making a claim to some way changing the technology, then you have an eligible claim and should be analyzed beyond that. So hopefully it's helpful to analyzing that. What happens if it's discovered in nature later? I mean, it wouldn't matter if it was discovered in nature later, because if you have what would the scenario be? Let's suppose you create some sort of new chemical compound that has never been discovered, and you claim that chemical compound, but you're going to have to describe how to make the compound, right? Because the chemical compound's never been discovered before. So no one knows how to make it because it doesn't exist yet. You just discovered it. So you're describing this new chemical compound, and you're going to have to describe some new way of making it, or some way of making it, period, because no one knows how to do it yet. So you're going to have to describe some way of making it. Now, if at some later point someone finds out, oh yeah, that chemical compound exists in nature, you still described a way of making it. You've described a way of synthesizing it. That's a technological improvement. So just because it's eventually found in nature is not a problem. The problem is what we're trying to do is improve the technology. Did you create a new way of synthesizing or creating a compound? Whether we know about it in nature or not at the time is irrelevant. Whether or not we find out about it later or not is relevant, because you still come up with a technological means of describing it, isolating it, synthesizing it, or whatever else it is you're doing that's technological in nature. So just because you eventually discover the thing in nature, you still describe some technological process of making it or manifesting it. So that's the question. If you describe something that is ultimately found in nature or biology or chemistry or physics or whatever, it's like, well, how did you describe it? If you don't know about it, if no one knows about it in nature yet, how did you describe it? I mean, you have to find some way of telling a person of ordinary skill about it. If no one knows about it because no one's discovered it yet, how are you telling them about it? It must be through some sort of technological process. And therefore, what's patentable is the technological process and the product at the end through the process. But yeah, I mean, that's not a problem. So hopefully that was a meaningful discussion of this. How much time do you have to do it? As much time as would be for the application. So the time is going to be based on the application, the need of the application. So it's like, you could probably do anything by hand eventually, but there's some practical limitations here that make it advisable. So yeah, it can be done pen and paper, but not practically. It cannot be done practically by pen and paper. It can't be done practically by pen and paper by 10,000 people. With any sort of you could get someone to you could theoretically play a video game by getting people to draw it by hand, right? You could theoretically have someone draw the first screen of Doom and someone describe, I do this, and then they actually hand draw the frames one at a time and actually play the game by hand drawing it. And in some senses, this is what Dungeons and Dragons people have been doing forever, right? Is they'll draw it and they'll show it and stuff, but it's your execution time is a relevant consideration here. And again, the issue is improving the technology. The fact that you can do it with a computer improves the technological progress, improves the progress of the useful arts. So that's really good. Humans can recognize faces, but they can't do recognition in their heads. How it's work in patents? Well, exactly right. It's can you get a machine to recognize faces or recognize anything else for that matter? Can you do recognition through machine learning or any other process? If you come up with a technological way of doing something a human being can do, it's still a technological improvement. So, if the fact, human beings can do some things much faster than a computer can, much faster than a computer can. But if you can figure out a way to get a computer to do it, then that would be a technological improvement. So it's not whether or not human beings can do it. Even then, it's an issue of, can you describe a new technological way of performing it, of increasing the process? So it's is there a technological method of doing it? If I just wrote, a claim for, if I wrote merely a method of recognizing faces, it would be patent eligible. It just wouldn't have any disclosure. So my problem isn't 101. My problem is 112 because I haven't written how to do it. Right? If you wrote nothing more than a computer comprising a method of recognizing faces, that would be 101 eligible. It wouldn't be patentable because it's not meaning 112 because there's no description on how to do it. Unless you tell people how to do it, you haven't invented anything. So yeah, it's patent eligible, but you have all kinds of problems before you get to allowability, like written description. You haven't told anyone how to build it. You have to tell people how to build it. If you don't know how to build it, you have a problem. If you do know how to build it, you've improved the art. So we're very happy to hear from you. So that's that's good stuff. Can you patent non-useful arts? No, it has to have practical effect. Of course, the practical impact can be somewhat impractical. I mean, it doesn't have to be useful to people at large. It would have to be useful to a person or an application in some sense. So would a Rube Goldberg machine be patentable? Sure. It's a new way of doing something, even if the thing is known. So if you had a Rube Goldberg machine to light a lighter, you could get a patent for the Rube Goldberg machine. I mean, there's a billion ways to light a lighter. You've created one of them. Congratulations on your patent for your one-of-a-kind Rube Goldberg machine. No one cares. You can do that. It's definitely useful. It lights a lighter. It's novel and non-obvious. No one would do it this way, and no one would do it that way, and no one cares. But yeah, you can get a patent for that. Sure, no problem. Patent the square wheel? Yeah, I mean, I would assume there's prior art or it's obvious, but sure, you can patent a square wheel. In fact, I wouldn't speak too broadly about it, but I would imagine there's some use case somewhere where a square wheel might be useful. I don't know what that would be, but there's got to be use cases where a square wheel would be more useful than a round wheel. Digging, it would help you dig into dirt. So, if you're climbing a hill, maybe it would be better because it digs into the dirt or something than a round wheel. I don't know. But there might be a use case for it. So yeah, you can get a patent on a square wheel. It might be useful. It's not useful in the vast majority of applications, but it might be useful in an application. As long as it's useful in an application, great. You've improved the state of technology. No one cares. It's useful to you. It's useful to human beings in some limited sense, but sure, why not? So yeah.